Ladies and gentlemen, thank you very much for the invitation. I'm really happy to be here. Allow me at the beginning some memories. As a child, being in age of 5 years old, I spent a lot of time in Miskolc because it's in the communist time in 1978. It was a place that many Polish have come just for swimming, the swimming pools and everything. And I have my personal also memories bond with Miskolc too, because in the age of 5, I learned to swim here. And this is something I own to Miskolc till now, because till now I am quite a good swimmer. So okay, the presentation works? Oh yeah, it's work. Okay. The title of my presentation is concerning the consular law from the perspective of internal law. Last time I spoke here in this forum in Warsaw about the consular law from the perspective of international law. Now we will take up some interest on internal law of states, which is, I think, quite more interesting. Let's start out. And I will analyze this issue also on the example of notarial activities. And on the end of my presentation, I take some de lege ferenda conclusions. I think it could be quite interesting because I suggest some changes in Polish internal law, especially because we have had some changes in 2019. They weren't, I think, good done. So first, let's start with some introductory remarks concerning international consular law versus something what I call is internal consular law. Because consular law is characterized by some duality. It's international law from one side, and the second side is the internal law of states. From international perspective, it's a branch of international law, and these norms, these rules are customary law, and also a great number of bilateral agreements. There are some bilateral agreements, so typically consular bilateral agreement, and also we have some agreements on civil legal aid. Some of these deal with the status of the consul, its nomination process, immunities, privileges, and facilities. Other agreements deal with some certain liberalized issues. In these issues, the role of the consul is diminished. It's normal because many multilateral agreements are dealing with some issues on the European Union liberalization system. It's transport of corpses, it's question of liberalization, of abolition of legalization, and something like this. The important is to mention about the role of the Vienna Convention on Consular Relations in '63, because it's completely different from that of the Vienna Convention on Diplomatic Relation. The first problem is that the Vienna Convention is used, this consular convention is used only when there is no bilateral convention, and bilateral convention are de facto lex specialis. So normally the Vienna Convention 63 is not used in turnover if you have some bilateral convention, as for example between Hungary and Poland. It's also not a comprehensive act. It refers only to particular functions, only those functions that involve the receiving state notification obligation. I have spoken about it last time, so I just summarized only this question. In fact, we have the interaction of 3 legal orders in question. The main scope of influence, they are rules of law of the sending state, because usually we have in functional terms consular law of the norm of the law of the sending state, ordered sometimes directly through the norm of international law, and sometimes limited by the influence of the law of the receiving state. So there are 3 different legal systems in order, but I think the most important from our point of view is the law of the sending state. The Vienna Convention 63 focus only on the classification of consular functions. Very important from this point of view is Article 5, which divides the functions by two different groups. There are functions which are granted by international law, and those whose exercise and scope depends on the receiving state's approval. And as an internal law, we can see 3 different parts of national consular law. The first part is institutional part, is the status of the consul, appointment, immunities, privileges. The second substantive part, there are consular functions. And the third part, it's the procedural part, is the mode of proceeding before the consul. In addition, we have also some extraneous part concerning the fiscal law. It means the consular fees, so fiscal part, and the special part in many national legislation laws. There is the honorary consul rules, which it's, for example, in Polish law treated differently, as the same as Hungarian law, in fact. In institutional terms, the law of the sending state is equivalent of canons created in the international law. So, in fact, this institutional part is parallel in internal law and in international law. In fact, in Polish legal system, we have quite the same regulation like we can find, for example, in the Vienna Convention 63. There are, of course, the question we usually find in international law is very interesting. So consular letters, exequatur, and in comparison, especially to diplomatic law, something like agrément, letters of credential, and so far. Also, the procedural part is the input of international law into the procedural scope is minimal. It's regulated generally by the domestic law of the sending state. I will leave this question to my friend Rafał, who will, in the presentation in 20 minutes, will deal with the procedural problems of consular law. But let's go now to the topic of my presentation. So, because we'll analyze which are the models of consular national regulation, especially in which part what are in fact how are these norms devised in national legal system. Some countries grant consular regulation in district systemic status, but normally it's something like licentia poetica of the states. They have some considerable distraction in shaping this regulation. The completeness of incorporating all norms relating to the consular service into a single legislative act is often questionable. In many cases, consular regulations are spread across various specialized legal acts, often of statutory rank, that pertain to specific legal institutions of areas of law. The number of countries are moving toward consolidating consular norms under a single legal framework, as, for example, Poland do. The similar consular law, national law, is the Romanian consular law, also in Italian, Lithuanian consular law, and Estonian. The most interesting regulation is the regulation of Belgian consular law, often referred as the consular code. Polish model, we have one act, in fact, one national act. There are some similarities to the solution adopted earlier in Belgium and Romania. It seems likely that the Italian regulation may have also influenced its development. We have constructed this act in 2015, and it was our third act on internal consular law. And as I was a member of a codification committee in Polish Parliament in this time, and really we have taken Belgian law, Italian law, and Romanian law in this time, and we have chosen some very interesting issues from this act, and we constructed our own Polish consular national. And we tried to construct something like comprehensive legal system, but Article 34 of the 2015 law referenced 22 specific types of activities, briefly describing them and performed by the consul under the authority of other laws. So we have some consular law, consular national law, but a part of this we have 22 other issues which are in other branches of internal law. The most important are the Act of Civil Status Records and the Act of Election Code. And in this acts, they are detailed provision concerning the election, the voting system abroad, and also the problem of registering the civil status abroad. but there are only two, and in other 20 legal systems there are some different rules. But our consular law is over 215 articles, so it's quite a large legal system in comparison, for example, to Hungarian law, which is the equally common solution is to limit the scope of such codification to basic institutional issues and at most a few fundamental consular functions. The other consular functions are regulated by separate provision of domestic law. In such a model, we have, for example, in German consular law 1974, or the Latvian consular law from 1994. In these countries, in some of the countries, certain functions of the consular are subject to a separate statutory regulation. For example, we have such Austrian regulation, Bundesgesetz, the Consular Beglaubigungsgesetz. There are some very specific legal functions as legalization or civil status record. The same we have in French consular regulation. There is some décret relative attribution des ministres des Affaires étrangères en matière de légalisation, attribut notariel des agents diplomatiques de droit de registre civil. There are some regulation concerning the problem of legal, very, very complex legal questions on legalization matters or civil status record matters. They are in some countries in other regulation than this main consular regulation usually, which is quite large. And also worth to mention some issues concerning the European impact on national consular law, because after European countries have accepted the Consular Directive on 2015 on protection of unrepresented civil, sorry, it's too hot for me here. On protection of people, they haven't been represented in European Union countries. Many countries took the opportunity to update them, to modernize their existing consular law, effectively giving them a facelift. And this was a case of Hungary, because in 2015, between 2015 and 2018, Hungary has made a facelift to consular regulation, the present consular regulation of Hungary, and they put into this regulation some questions concerning the protection of citizen abroad, unrepresented citizen in Hungarian consular law. As a result, consular law across various EU member states have undergone significant changes in recent years. So this is, we have accepted many changes in this time. So since 2018, we have in many countries, European countries, have a new consular national regulations. And now let's go to some questions concerning notarial legalization functions, because they have remained outside of the scope of EU regulation. We can speak about common consular law concerning the protection of citizens, but we cannot speak about the common regulation on EU, common regulation concerning the notarial or other civil actions. Acts performed under foreign legal norms are recognized domestically only in accordance with the rules of private international law. So this harmonization on notarial activities across EU states is neither feasible nor practical. So it's not easy for consul of other EU states to make some notarial function for other country of European Union. It's impossible because it will be foreign act in this moment. So there are not common rules to make this action joint for all the European Union. Other question is in contrast with legalization activities. They could potentially involve the consul of a foreign state producing a legal effect of another country. Because we have such practice in Latin American countries since 200 years in Latin American countries, there is something like Nación Amiga action between the Latin American countries, consular officer of Latin American countries. It means that one national consular officer of one, for example, Honduras, can make legalization actions in the name of another Latin America country. As a effect, they will be recognized in both of these sending states. But such a situation is impossible from the point of European Union, because we have very, very different legal systems. For Latin America, it's very easy to make some changes like this, because they have the same civil law system, they have the same language, they have not all the countries, because, for example, Brazil is Portuguese, but it's really the same legal system. They have the same backgrounds, they have the same rules of action, so it's very easy. From the point of European Union, is also without sense in this moment, because we have something like diminishing importance of consular legalization in contemporary consular law. We have accepted a lot of multilateral convention concerning the abolition of legalization, so in this moment is no sense. But now take a look into the perspective of sending states law concerning a notarial act performed by the consul. From our point of view, the act made by consul abroad is the domestic act. So usually the acts done by a consul as a notary, they have evidentiary power, and it means that the ability of the document to be considered as evidence in domestic procedures. It's worth to mention that this evidentiary power is generally binary. It's either the document possesses evidentiary power or does not. It's not, the document cannot have evidentiary power in part, so it's generally binary. However, the mere existence of evidentiary power does not automatically confer evidentiary value, because different legal systems within the respective rules of evidence evaluation may ascribe varying levels of evidentiary value to documents based on factors such as identity of issuer, the date of issuance, of other relevant considerations. And also worth to mention that some references to such practice can be found in modern laws, often in provision, as for example in Article 30 of Belgian consular law, which provides that notarial act issued by competent consular officials and used in Belgium are exempt from any form of legalization. We can see that there are two characters of notarial functions of consul. There are two regulatory models. It is worth to mention in the beginning that there is no significant need for consular service to specialize in performing notarial activities. Because in practice, the professionalism of consular staff in this area is limited. Even with excellent training, it is unrealistic to expect consul abroad to stay updating on the evolving legal standards, precedents, and jurisprudence of domestic civil law. As a result, consul typically handle only with a simple task, minimizing the burden associated with such activities. And there are two different models. The first model, there is closed model of notarial function of the consul, in which the sending state explicitly defines the specific notarial activities that its consul are authorized to perform. All other notarial functions are unavailable abroad in consular form. This approach often results in the formal closure of the catalogue of notarial activities in statutory acts. Of course, it's not ideal from the perspective of development of law. Such a closed model, if, for example, we need something like legislative action whenever new needs emerge, what's often with significant delays. These delays, of course, can disadvantage individuals, as legal adjustments are typically reactive and require statutory amendments to address newly arising civil issues. But it's worth to mention that the closure of the catalogue of notarial function is not necessarily tantamount to small numbers of the function performed. Because when a closed catalogue of activities is broadly defined, it generally has minimal impact of consular activity and the ability to meet the needs of the sending state's citizen. For example, such situation we have in French consular law. The French consular are governed by precise, extensive, and source complex catalogue activities, which is formally closed. However, due to the comprehensiveness of listed functions, amendment to expand the scope of notarial regulations are rarely necessary in practice. In Poland, what is interesting, a closed catalogue of consular activities was introduced in 2019 on the law of amending consular law. It was in practice the removal of the FAS in particular from the Article 13, and it was from formal point of view a closed catalog of activities, with the introduction of a closed catalog of activities. Of course, there are two different reasons to close the catalog, because from one point of view, first we must ensure the highest level of security and accuracy in execution of a notarial act, particularly given the potential lack of specialized legal expertise with the foreign service. So if our legal service of consuls is really not well they do not have professional training in notarial activities, so it's better to close the notarial function of consuls, because they couldn't make any mistakes in this acts. But from another point of view, we must safeguard the rights of citizens by guaranteeing the access to the proper jurisdiction of the sending state. And from this point of view, it's better to remain the open catalog of consular functions. We had such open catalog of consular functions in last year, till 2019. It allows for the evolution of consular function over time, because if you have some new introduced notarial function, when recognized within the legal system of the sending state, can be automatically carried out by the consul without the need of further legislative intervention. In present consular law of the states, we have many examples of opened catalog of notarial activities, especially in Kazakhstan, Lithuanian, Italian consular law, German consular law, Portugal consular regulations. Also, among the Central European countries, Article 14 of the Hungarian consular law is particularly notable, because we have something which allows for the authentication of other facts or circumstances of legal significance. It means that we create de facto unrestricted catalog applicable to professional consular officers. So the notarial action of Consul of Hungary, it's open from this point of view. In contrast, honorary consul are always subject to a closed catalog of notarial functions, which is stipulated in Article 14, para 6 of the Hungarian law. Very interesting catalog of the action is in the Belgian consular law, because it appears at first glance to be closed, but however, this Article 18 does not enumerate specific notarial activities, but instead broadly references matters of civil law, which include areas such as property law, testamentary law, matrimonial and property relation, a certain aspect of adoption. As a result, within these specific areas of civil law, any formal notarial act is recognized under Belgian civil law. Consequently, this formulation function is essence as an open catalog. It's also worth to mention that as a general law, an open catalog of notarial activities we can see in common law jurisdiction. However, there is some fundamental distinction between the action of notary public of common law states and civil law notary in our legal tradition. In common law jurisdiction, consular law typically contain only broad general references to specific notarial act without imposing restrictive limitation of their scope. But the function of notary public within the common law system, there are some narrow functions and they are not comparable with the action of notary from the Roman law point of view. Consular law of common law countries mainly concerns institutional matters, the position of the consul of the foreign state in these countries. Only few norms relate to the activity of the consul of common law state. The exception, of course, being in the provision of notarial activity, as I have mentioned before. It is different from the states of our legal culture, which primarily regulate the legal position of their own consul. We usually regulate the position of the Polish-Hungarian consul abroad in our consular law. In common, for example, in Australian and British consular law, they usually regulate the situation of foreign consular officers in our states. So there are some different traditions of consular regulations. It's really different from the states of our legal culture. We primarily regulate the legal position of their own consul, and to the position of the foreign consul, we refer to a limited extent. In fact, we give this matter to international regulation, as for example, Vienna Conventions. It's also worth to mention the open catalogue of notarial functions that derives from numerous bilateral consular conventions. And the scope of notarial functions may be here subject to some limitations, because the first limitation derives from a letter of commission, so the sending state can limit the scope of notarial function. And also this limitation can derive from the exequatur mechanism applied to this letter of commission. It serves as a potential instrument for restricting the catalogue of function performed by the consul. Also, we have to mention that this convention allowed the receiving state to limit the effectiveness of consular function with its territory without necessarily restricting their performance. For example, the consul of the sending state, according to the bilateral convention, can, for example, make some acts concerning the real estates in the receiving state. But of course, they can be performed, but they will not effective, in fact, because the receiving state will restrict the effectiveness of some acts concerning real estates. It's usually such regulation can be found in bilateral convention of the states. And let's go to the finish. What's interesting in this model that assumes an open catalog of notarial activities from consul, there is a significant risk that in practice many functions may be seen only limited application. This is primarily due to the level of practical training received by consul, which correspond to the infrequent nature of such activities and may not adequately equip them to independently structure and execute notarial acts. Hence, some notarial statutory frameworks address this challenge through external facilitation mechanism. What is important, we can provide for the involvement of notaries from the sending state in drafting the context on consular notarial act. In this regard, in European countries, we have two interesting regulations. The first one is the Lithuanian regulation. The second one is the Belgian regulation, that they can serve as our noteworthy models. And let's take a look into the Lithuanian first, and after some remarks concerning the Hungarian law, and then we go to the Belgian model as an example for for changing into Polish law. The Lithuanian law in Articles 32 provides the possibility of consul obtaining information from the notary self-government. The provision states, if necessary, the notarial notary chamber shall provide consular officials with information regarding the performance of notarial activities. This wording suggests that the exchange of information may extend beyond general guidance to include the transmission of draft notarial deed, which the Lithuanian consul would then read out abroad. It is worth noting that also the Hungarian law also explicitly provides for the exchange of information between the notary self-government and consul or the Ministry of Foreign Affairs, but solely in the context of legalization activities. According to Article 15, the Hungarian Notarial Chamber, National Chamber of Notaries, is responsible for the pre-legalization of Hungarian notarial documents intended to use abroad before these documents are forwarded to the Ministry of Foreign Affairs for further authentication. This provision shows the notably very strong position of the Hungarian notarial self-government. It's really, from my practice as a notary, throughout many years in Poland, I can say that the Hungarian notarial self-government is really strong. I think it has the strongest position in Europe, after maybe French notariat and Romanian notariat. So there are three main, very strong notariat chambers with big power and the big possibilities to involve for other states' agendas and so far. So I think notarial of Hungary is a really strong one. Not Polish is very weak, in fact. And it's quite interesting. But the most interesting from this point of view, the Belgian model. The Belgian model in Article 18 explicitly admits the possibility of the consul reliance on the work of a civil law notary. The provision states that consular officials may ask the parties to submit a specimen of notarial, means a draft of notarial deed to be drawn up by the Belgian civil law notary. So the contract between the Council of Notary is not established directly, but occurs throughout the parties to the action who submit to the Council a draft of notarial act previously prepared by a civil law notary in Belgium. This solution, of course, offers several advantages because first, of course, the cost of preparing the draft deeds to the party. So we avoid some, I'm just finishing. We avoid financial burden of the consul. And the second, it allows for a significant expansion of the scope of notarial activities performed while assuring their professionalism, which would not be possible in the case of the consul acting independently. In theory, this mechanism effectively expands the consul catalog of notarial activities and address potential future challenges. And let's go to the end. I'm just finishing. Let's go to some comparative remarks on Polish law, because in Polish regulation, it's worth nothing that our catalog of notarial activities is closed, but there is the possibility of granting so-called notarial deed to certain action at the request of party. Theoretically, it allows for expansion of consular function in rare of exceptional cases. It is because our Article 91 of Act of Notaries in conjunction with consular law opens a catalog of our function, because pursuant to Article 91, the notarial deed is a special form of notarial act. The notarial deed can be constructed not only when the law mandates to use this form, but also when the parties to the transaction expressly chose it. So if, for example, there is a will of the party of the transaction to construct notarial deed, so the notary must construct notarial deed. The same we have in consular law. But if the notarial deed is constructed by the notarial deed can be constructed by consul only after this, he will receive from the Ministry of Justice consent. This consent is granted at the request of Ministry of Foreign Affairs. So in fact, it takes a lot of time to perform such notarial deed before a consul. So, what kind of de lege ferenda conclusion in this context? Because the Belgian model could serve as a reference for potential reform of Polish system, particularly in terms of liberalization. This possible improvement would be to exclude notarial deed drawn up by the consul based on the draft prepared by a Polish civil law notary from the requirement to obtain the Ministry of Justice consent. Now we have something like consent of the Ministry of Justice to construct notarial deed. My proposal is to avoid this regulation and just to introduce something like notarial deed drawn up by the consul based on the draft of the specimen prepared by Polish notary. If we had something like this, if we will introduce something like this, it would be I think of a good proposal, because it would now the current system it's really prolongs the process. So usually the parties are waiting for a notarial deed done by consul 3 months or more, because there must be a Minister of Justice consent, and the first must be the request of Minister of Foreign Affairs. It takes a lot of time because this consent is for every one notarial deed. It's not the consent in abstracto. It's Minister Piebiak, as was Minister of Justice, Vice Minister of Justice, has prepared a lot of such notarial deeds. How many such deeds give you signs in 1 year? How many? 100, 200 in Polish consular practice? How do you think? So, but they are not so many. So, in fact, it would be for Polish civil law system. It would be very, very interesting because of the safety of system. Because if the notarial deed is constructed by Polish notary, it's much better that it would be constructed by, for example, a public notary. I don't know, United States and United Kingdom, because this without evidentially force, in fact. So the probative force of acts constructed by civil law notaries in New Zealand, in Australia, it's close to zero, in saying frankly. So it's much better to construct something by consular officer of Republic of Poland. It could be something interesting. And we have been 3-4 years ago very close to reach this aim and to construct such regulation in Polish law, but unfortunately the Polish government in this time rejected these proposals, but maybe with the help of God, we will come back to our proposals in the future, I hope. So thank you very much.